Mukaona zimai ya kulila mumamva bwa akamuchotsa chibelekelo mumamva bwa sonsezi zapeweka kati tisi mtachina chake lamula la uchembele liulikire.
Welcome to today's edition of Freedom and Choices. Freedom and Choices is a sexual and reproductive health program produced by Center for Social Journalism. In today's program, I'm chatting with a legal consultant Mateyu Sisya. Enjoy with me, Grace Makina. You're welcome, sir.
Thank you, Grace.
First of all, what are the sexual and reproductive health rights?
All right, to answer your question, or to begin with, we need to understand that each and every human being has got human rights. The moment a person is born, they are born with the human rights. So, in the field of sexual and reproductive health, people also have rights. For example, people have got the rights to access contraceptive services. People have got the rights to go to the hospital and then ask for treatment when they have got a sexually transmitted infection. In any case, when we look at the law, for example, the Gender Equality Act, which was enacted in 2013, we read the section 19. It specifically says that every person has got the right to sexual and reproductive health services. So the rights have been listed down as access to sexual reproductive health services, access to contraceptives, to choose when to have children and the number of those children, and they can also choose either to have children or not. They should not be forced to have children. That's a human right. That's a sexual reproductive health right. And to go on as well, it says that when you want to access sexual reproductive health rights, you don't necessarily need the consent of any other person. For example, if a person is married, they don't need the consent of their spouse to go and access sexual reproductive health services. Another example would be the youth, a person who is at least 18 years of age. They can go to a hospital to access contraceptive services, sexual reproductive health services, without necessarily being accompanied by their parents. So, in a nutshell, that would be some of the sexual reproductive health rights.
Okay, so what are the common sexual and reproductive cases that our courts usually deal with here in Malawi?
Most of the cases that can come to mind would be where the hospital has been negligent in providing those sexual reproductive health services. But recently there has been a case where a girl who fell pregnant because she was sexually assaulted wanted the pregnancy to be terminated, but the hospital refused because they say the law doesn't allow them. So that's one of the cases that is a classic case where a person goes to seek sexual reproductive health services because he didn't want to have that child, as the law says, as I have said, that the law has said you can choose whether to have a child or not. So this girl says, I don't want this child because it has come out of sexual assault. So that's one of the examples of sexual reproductive health rights cases that has come to the courts.
Okay. At what age should people start to enjoying their sexual and reproductive health rights, and why?
Well, to begin with, the law does not specifically say at what age.
Okay.
As long as somebody is mature enough, they can access sexual reproductive health services. I'll give an example. There is a piece of legislation or a law which is called the HIV and AIDS Management Act. In section 13, it says any person who is at least 13 years of age can access HIV testing services. So you can see that the law does not hinder any person who to access those services. So there's no specific age at which a person can access sexual reproductive health services. There is nothing in the law that says that. But because of maybe stereotypes, stigma, people would say young people should not access sexual reproductive health services. But when you read the pieces of legislation that are there, it doesn't give you an age limit. As long as you go on and access those services, as of right, as I said at the beginning, that it is a human right. So human rights apply to everyone, whether you are a child, whether you are married, whether you're not married. So it's universal. It applies to each and every person. So there is no specific age.
Okay. We have legal marriage age of 18.
Yes.
But why do we still have the problem of teenage pregnancies?
You have already said that the legal age of marriage in Malawi is 18. It is actually provided in the Act. I think there is what they call Marriage, Divorce and Family Relations Act, Section 14 to be specific. It actually says that those people who should enter into marriage should at least be not below the age of 18. However, as I have said, sexual reproductive health services are as of right. So every person can access those. And it is common knowledge that the people as young as 15, 14, they have started to engage in sexual activities. Because some of them would not want their parents to know, or they would not want to go to the hospital to access services. That's when they become pregnant, because they don't want to go and access these sexual reproductive health services. And in addition, some medical personnel would shun at those young people who have come to the hospitals and tell them that maybe it's not in the Malawian culture for people of that age to access sexual reproductive health services. So in a nutshell, what I would say is the access to contraceptives, reproductive health services is what there are barriers to that. That's why there are a lot of teenage pregnancies, and maybe the information out there is not adequate for them to go and access these services.
Mukaona zimai ya kulila mumamva bwa akamuchotsa chibelekelo mumamva bwa sonsezi zabeweka kati tisi mtachina chake lamu